I mean, just as a sort of a general question, maybe to get into some more subjects.
There's so many complications. If I could just build on what you said at the very start of the question, the last question, the fact gathering at the start of my interview is the most important part. You have to determine all the assets they own, whose name they're in, and you have to understand the family. Are there any disabled beneficiaries, children? What are the issues? Because if you don't have that information, I can't build the right plan. One of my greatest ways to market is I give free reviews of anybody's existing documents, and 90% of the time I end up redoing them. One of the problems in my business is that every lawyer will say they do wills. Very few specialize. Try it sometime. Next time you run into a lawyer, say, do you do what? Yeah, of course, and they've got a secretary in the back doing it or whatever, but how many of them spend 70% of their time doing it? I usually find something wrong, and it's not what's on the paper. It's just like a wills kit. What's wrong? It's the questions that aren't asked. It's the information. It's holding the assets wrong. Maybe they're joint when they shouldn't be. That sort of thing. If you don't ask the questions, you don't have the facts. And I'm sure, Brent, you're the same way. You have to understand all those facts before you can then build either for me the estate plan or for you the retirement plan.
So again, it's the same sort of profile building, working with the client. We talked about sort of profiling and getting the person who's actually getting the will together. What about the people he's entrusting to take care of that afterwards? Is that something they have to talk to them about and make sure they're aware of all the work involved?
They certainly should. That person would be called an executor or an estate trustee, and they will be working with a lawyer for a year to 2 years, gathering in the assets, probating the will, working with a lawyer to probate the will if that's required, dealing with all the beneficiaries, dealing with all the tax returns. It's a couple of year job, and I've got a handout that I give to clients that are thinking of becoming executors just to make sure they read it. Ask people if you're ever in a crowd how many have been an executor before and would they put their hand up again, and sometimes they don't put the hand up a second time. It's a lot of work. I mean, they are entitled to compensation. A spouse, if they're the executor, they're not going to charge compensation if they're inheriting the estate. But if, say, an uncle is being the executor and they're giving it to, 3 nieces and nephews, then there'd be compensation, which is generally 5% of the value of the estate up to $1 million, and that decreases after that. Okay. But it's worth it. It's a lot of work.
A lot of work. What to
be the executor?
What do you have to do? What do you have to do over that? You said meetings and working. And
you're totally liable for handling the investments. If it's a long-term trust, you hire a financial advisor to come in and help you. But you're liable for every dime that comes and goes in that estate, and you have to type up accounting showing where every dime went and everything that was earned. And there's a lot of responsibility to it. In my practice, 90% of my clients that come in with an estate, the executors come in to see me, and they will hire my office to do all that work, and then I'll share the compensation with them because they don't want to do it. They don't have staff to do the accountings. They're not interested. So in my practice, I do a lot of that work. I'm probably the executor in maybe 30 ongoing estates right now. It's just a job that I've taken on. Is
that part that you work with clients as well, is deciding on who the executor should be?
Yeah, if they've got kids that don't get along, or there's sometimes where right away they don't want their children.
Back to estate planning. When do you probate a will?
You have to probate a will if there's an asset that's owned by the estate that it requires probate. So that sounds circular, but if you have a bank account that's generally now up to $30,000 in a bank, they will not require probate. $20,000 to $30,000. You can sign just an indemnity to pay them back if someone comes up with a newer will. Really what probating is going to the court and having them stamp the will and saying this is the last will and testament of this person that passed away. So everybody, all the banks and institutions can say, okay, yes, they can deal with that executor because this is a court-approved will. If there's a very small estate, then you're not going to require it. If it's a first of a couple to die and everything's owned joint or designated to the surviving spouse, generally you don't have to probate the will unless there's a fight going on, and then you may have to do it. But 99% of the time you don't have to. But on the second to die, you do have to do that, and you have to pay the government a 1.5% probate fee to the court for the privilege of them stamping it. So it's a bit of a tax that the government has slid in there. But there's some on larger estates, there's lots of planning we can do around that, but for smaller estates it's not worthwhile. You just pay it, and it's part of the cost of
what do you do to work
to avoid it?
To avoid it, I guess.
To avoid the probate fee. A lot of people use joint ownership, like I just mentioned. If you own everything joint with your spouse and you die, there's no requirement to probate the will. The problem comes when there's one spouse left. I get clients come in about once a week with their kids and they say, I want to flip the house to my name and the kids, and I go, hold it. You're exposing your house to your kids' creditors, your kids' family law claims. Mom or dad, a little bit older, you know, they're 60s or 70s or whatever, that's a pretty safe place to keep the house. The chance of them, they could still get remarried, but the chance of them, you know, getting more family law claims or creditor claims very small compared to the children. I've seen houses lost because the kids get involved, and to me, you pay the 1.5% and protect your 100%.
So you say people coming in, is it a misnomer that that's a good idea to do that?
Oh, the banks argue very quickly to put things joint with the surviving spouse with children to give them access to the account. And I spend a lot of time saying give them signing authority, not joint ownership. There's also tax issues when you start to put assets into joint names. In the house particularly, if the child already has a house and you put your house joint with them, they've lost the principal residence exemption on that portion of the house. So there's tax issues. Like with spouses, I have no problem with joint ownership. With children, there's lots of problems. I can give another seminar on that one. There's some there can be issues with, like, for instance, on the RSP, if you designate beneficiary, they get it tax-free, but the estate pays the tax. With a spouse, the spouse can roll it over into the RSP, but if you designate your children, like I said, when one spouse is gone and you want to avoid the probate fees, so you designate say one of your children, the estate pays a tax. So you have to make sure if you got more children, you name all the children as the beneficiary. Right. Otherwise, your other kids are caught with the tax, and that son got it tax-free. Right. Not very good for the family morale. Right. I can give you a couple more, Sean, of scenarios on how to avoid probate fees with clients that have a bit more complex situation. The designated beneficiary on insurance policy, that's an easy one. We do that all the time, and we can also avoid the probate fees if we set up something called an insurance trust outside the will. It's a very simple thing to do. So if someone's got $1 million policy, it may well be worth doing that. The other way to avoid probate fees is if the client, Brent was talking about clients with businesses. I have a lot of clients with businesses, or whether they're farm corporations or other incorporated entities. We can do a second will just dealing with those shares, and we can sometimes deal with real estate and personal property too. I've got some clients with china collections and doll collections worth $200,000 or $300,000. We can roll them all through the second will, and we save the 1.5%. So there's some ways to get around it if the clients are interested.
Okay. So we've talked about sort of avoiding the probate fees, but what about just on a will in general, minimizing that taxable portion of it, and the government, because the government's always looking to grab a little bit here and there, right?
Well, the two taxes that we deal with in estate planning are the probate fees, the probate tax we just talked about, and the other one is capital gains tax.
Capital gains.
In Canada, there's no more succession duty or inheritance taxes, but when you die, you're deemed to sell everything you own. So if you own stocks, bonds, or an investment property, there could be capital gains. If you leave it to a spouse or spousal trust, there's a rollover. But when on the second to die, when the first, the second spouse dies, then tax, you can't avoid it. There's going to be capital gains tax.
Okay, a little bit more on just capital gains, because what is it by definition?
It's say you had a portfolio that you paid $100,000 for in stock, let's say, or mutual fund, and it went up to $200,000 by the time you died. The gain would go into your final tax return.
Tax return.
50%. And 50% of it.
Yeah. And also all the RSPs or RIFs you've got left when the second spouse dies, because you're leaving it to kids or it's payable to a estate that comes in, the tax, all of it goes into income. So that can be a huge tax.
Yeah.
You can't avoid it. You didn't pay the tax going in, you got to pay it going out.
Got to pay it going out. Yeah. Okay. But is there ways to mitigate against that?
I say talk to your accountant and draw down to the next tax bracket.
Right.
So if you die with 500,000 in your RSP or 100,000 in your RSP, it all goes into tax. So a lot of it's going to be taxed quite a high rate because it's added on top of your other income.
That's right.
Whereas if you draw it down to your next level during life, get rid of it as soon as possible, but move it over into non-registered. We're not saying spend it. We're just saying get it out on a tax-efficient basis.
Yeah, that's a good point.